most important legislative law passed by this president.
Oh, boy.
We have breaking news here on the Fox News channel. The individual mandate has been ruled unconstitutional. This was a part of the law that was at the center of the oral arguments 3 months ago on this day, when the justices hammered away at the White House and the administration's attorney, questioning the validity of the individual mandate and asking the following pointed question. If you can legislate health care, where can the federal government be stopped? Shannon Bream is live outside the Supreme Court now with more. Shannon, good morning there.
Good morning. We have just gotten the opinion. I'm just getting a first look at it. It is authored by the Chief Justice John Roberts. He has language specifically going to the Commerce Clause and whether the mandate is okay or not under the Commerce Clause, Congress's power. He says this compels individuals to become active in commerce by purchasing a product on the ground that their failure to do so it affects interstate commerce. He says the individual mandate cannot be sustained under Congress's power to regulate commerce. That means the mandate is gone. Chief Justice John Roberts writing this. We'll take a look, and I'll try to get to the severability as well, because now we're going to get to severability.
All right, Shannon, because we are looking at this, and we're trying, we talked about the fog of law, and to our viewers at home, be patient with us as we work through this. Megan, you're seeing something now.
We're getting conflicting information. We're getting conflicting information. If you follow SCOTUSblog.com, which covers the High Court,
correct,
they say that despite what Shannon just read, that the individual mandate is surviving as a tax. This is not confirmed by us yet. This is according to SCOTUS blog, which also has the opinion. They had challenged this individual mandate, and the government defended it on a couple of grounds. Number one, they said they could do it under the Commerce Clause because they have the power to regulate commerce under Article 1 of the Constitution. Number two, they said we can do this to individuals, force them to buy insurance or pay a penalty because we have the ability to tax people. And according to SCOTUS blog, I haven't seen the opinion, they're reporting that the individual mandate survives as a tax. So it may have been struck down under the Commerce Clause power, but spared under the taxing power. Everyone's still trying to figure this out. It's very fluid right now.
Understood. And also, Judge, was the word tax used in the 2,400-page law?
No, it specifically was not used because one of the issues was, is this a tax, in which case the Constitution requires that it be applied equally, or is it a fine, in which case people are being punished for not engaging in certain behavior and they can challenge the fine.
Let me stop you right there because this is complicated and you follow the blog and we're still trying to figure this out. Be cautious with us. We're trying to do the best we can right now as we sort through it.
And we need to update our lower third, which may not be correct right now.
It may take several minutes or even beyond that to understand all this. There are reporters still inside the courtroom trying to parse the language. Back to Shannon Bream now with the papers in her hand. Shannon, what do you see?
Okay, as we initially read, under the Commerce Clause, this mandate is not going to be upheld, and it's not going to be upheld, as Megan said, under the Necessary and Proper Clause. We're going through the language on the tax and whether or not this would be a part of the courts or Congress's power to tax. So no under the Commerce Clause, no under Necessary and Proper. We're getting to the tax now and getting to that portion of the opinion, and there is conflict on what we say here. But under the first two arguments, as Megan said, mandate doesn't survive. We're trying to read now from the Chief Justice's opinion about whether this survives as a tax. Mandate need not be read to declare that failing to do so is unlawful. Neither the Affordable Care Act nor any other law attaches negative legal consequences to not buying health insurance beyond requiring a payment to the IRS. Congress's choice of language, stating that individuals shall obtain insurance or pay a penalty, does not require this to be read as a punishment. So it's not a penalty. The court is saying we do read this as a tax. So under the direct tax clause, we are getting to that. A tax ongoing without health insurance is not like a capitation or other direct tax. It therefore need not be apportioned so that each state pays. And then we get into even more complicated language on the spending clause.
All right, Sharon, let me interrupt you only because I want you to get a chance to get a good look at that now. There's also word coming down now that the Medicaid provision, this was item number 4, is limited but not thrown out, not invalidated. And that was the Medicaid provision that required states to beef up their rolls to cover more people under the insurance clause. The mandate said to be constitutional, and Chief Justice John Roberts, according to this report, joins the justices who represent the left-leaning side of the court in that decision. Megan.
That is huge. That is huge. I mean, listen, for the folks at home, who are interested in what's going to happen to this law, you don't care whether it's upheld under the Commerce Law or clause or upheld as a tax. The question is, has the individual mandate been upheld or has it not? And it appears that the answer is the law will stand. The individual mandate, which is the heart of the funding mechanism behind the law, will stand not under the Commerce Clause powers of the Supreme Court of the Congress, but under the taxing power of the Congress, which was very controversial because this administration had represented to the American people that this was not a tax. They had said all along this was not a tax. But when they got into court and needed to justify Congress's behavior, they did a 180 and argued to the justices that they could do this under the taxing power. And it appears now that the Chief Justice, a George W. Bush appointee, has joined with the 4 left-leaning justices on the High Court. I don't know whether any of the other conservatives have. It looks like it may be a 5-4 decision to give them the 5 decisions they need to uphold the individual mandate.
I'm just reading this now. It's a headline alert. Chief Justice Roberts says the mandate is not a valid exercise of Congress's power under the Commerce Clause and Necessary and Proper Clause. Shannon Bream has more now. Shannon, what page are you on at this point?
44. And as we told you at the top, no under the Commerce Clause, no under Necessary and Proper, but yes, it appears under the taxing power. This is the key line from the Chief Justice's opinion. The Affordable Care Act's requirement that certain individuals pay a financial penalty for not obtaining health insurance may be reasonably characterized as a tax. Because the Constitution permits such a tax, it is not our role to forbid it or to pass upon its wisdom or fairness. That language from the Chief Justice sounds like, though no under Commerce nor under Necessary Proper, that sounds pretty clear that under the tax provision and the power of Congress to tax, that under that particular reading, this survives, apparently because of that language, because the Constitution permits this kind of tax. It's not our role to forbid it or to pass upon its wisdom or fairness. That's on page 44 of the opinion for those who are following along or have a copy.
How many pages are there? Is it several hundred, by the way? Just to get it.
Well, I'd say a couple hundred. It's broken into several different 50 to 60 page opinions and chunks.
Understood. Okay, so keep reading that. I'm going to get to Karl Rove, and I judge you want to pop in.
Here's the bottom line from SCOTUS blog, which is written by a Supreme Court expert that Megan and I both know personally. The mandate is constitutional. Chief Justice Roberts joins the left of the court. The entire Affordable Health Care Act is upheld as constitutional, with the small exception that the federal government's power to terminate the state's Medicaid funds if they are not spent as the feds command is reduced.
That was item number 4. To Karl Rove in Austin, Texas. Karl, based on what we're learning at the moment, based on what we know or think we know, your reaction?
It'd be an extraordinary step. I mean, the court tosses it out on the grounds of that it was sold to the country on, that the government had the right to compel everybody to purchase insurance as a condition of being alive, and instead upholds it on the basis that the administration was unwilling to make at the time, which is this is a tax. If this is actually the decision, it's a boost for the president. It is, but it doesn't make the controversy go away. In fact, it probably enhances the controversy because, like so many other things connected with this act, the premises on which it was sold, this is not a tax. You can keep your plan if you want it. It'll reduce the deficit. All these things turned out not to be true, and they're upholding it on the grounds that it was not sold on.
All right, dissenting justices include Scalia, Kennedy, Thomas, and Alito. It appears at the moment that Kennedy was not the wild card justice in this. It was the Chief Justice, John Roberts. Karl, who leads on the Republican side on the repeal? Does the House go first, or do they work in concert with Mitt Romney and allow him to?
Well, the president, the House has already passed measures that start to chip away at this. I would suspect they would likely hold a vote on repeal sometime between now and the election. But clearly, this now will turn to a dispute between the two candidates for president, with President Obama saying, I've now been vindicated by the court, and Governor Romney saying it may be constitutional, but it's unworkable, unaffordable, and wrong for the country, and I'll repeal it.
All right, we continue to go through this. I think it was just yesterday when Mitt Romney was on the stump in Virginia. He said, quote, my guess is that they are not sleeping real well at the White House tonight. That was yesterday, and today is today. Chief Justice Roberts his vote saved the Affordable Care Act. That's the latest line from the blog at SCOTUSblog.com. Carl, stand by from American Crossroads down there in Austin, Texas. Back with Megan and the judge in New York.
You know, the court found a way to avoid giving Congress this huge sweeping power that it was claiming it had under the Commerce Clause to regulate you even if you never step foot in commerce, saying that just sitting on your couch, never going to see a doctor, they could regulate that if ultimately you needed a doctor and somebody else had to pay for you. The court has rejected that and has limited Congress's powers under the Commerce Clause. This is very rare for them to do, to say that Congress does not have the power under the Commerce Clause to pass a law as it did here. So to the extent this Congress was seeking to expand its powers to regulate people's lives under the Commerce Clause, their wings have been clipped on that argument. However, the taxing argument, which people were not paying a lot of attention to, has resonated with this court and most importantly with the Chief Justice of the United States. And so our viewers know the way they decide when they go back into conference after the argument took place. The justices sit down, only the 9 of them go into the room. The Chief Justice starts the discussion as the most senior justice. He is given the opportunity to speak first, to cast his vote first, and then they go around the table in order of seniority. One wonders whether that day, on that day, at that moment, Chief Justice Roberts changed the future of the country on this law by being the first and the conservative justice to say, I believe the law stands based on the Congress's
Judge,
taxing
stand by
power.
one moment. Back to Shannon Bream. First, Brett Baer. And Brett, this is the headline at the moment for all of America. And a major victory for the Obama administration. The U.S. Supreme Court on Thursday ruled that Barack Obama's signature health care law is constitutional. In Washington, your reaction now.
This is an amazing moment for the Obama administration. And the fact that we as court watchers and all the reporters were focusing in on Justice Kennedy as the swing vote here, when it was really the Chief Justice, John Roberts, who was the swing vote and is the decider, really, on upholding Obamacare, as is written, as we've been talking about. Remember, in the immigration vote, people looked back and said, is this an indication that Roberts could be siding with the left even on another case? And people said, no, it's apples to oranges. But it seems that John Roberts has accepted that line of argument. And it's interesting, one more thing politically. As this case was being argued before it became law, as it was a bill, President Obama said this was not a tax. No way it was a tax. And he said it repeatedly. His legal team fought it as a tax, and they made that case in court, and this is what has upheld, it appears, his health care law.
And now to the politics of this. Remember, in the Senate, it was a party line vote. Not a single Republican senator voted in favor of it. 34 Democrats in the House voted with Republicans. Not a single Republican voted in favor of it. Shannon Bream has a couple hundred pages in her hands now. What did you find out, Shannon?
Well, it's interesting. There was so much focus on Justice Anthony Kennedy that he might be the swing vote here, but the dissent is made up, at least this primary dissent we're reading now, Justice Scalia, Kennedy, Thomas, and Alito. So like you've been saying, the Chief Justice turned out to be the swing vote here. Here's part of the dissent, and there is powerful language here. It says basically what's happened here is you've extended federal power to virtually everything. All of us consume food, and when we do so, the federal government can prescribe now what its quality must be and even how much we must pay. But the mere fact that we all consume food and are thus sooner or later participants in the market, their quotes, for food, does not empower the government to say when and what we will buy. That is essentially what this act seeks to do with respect to the purchase of health care. It exceeds all federal power. So a strong dissent there, but it includes Kennedy. Justice Kennedy goes with the dissent on this, with the wing, often viewed as the conservative. So it was the Chief Justice, as we're seeing as we parse through, who clearly was the deciding factor in this
All right, Shannon,
decision.
Thank you for that. We're getting word from the White House. President Obama will talk about this, his first comment coming within about 1 hour. So we'll stand by for that at the White House. You wonder how Medicaid, if that is struck down, how more Americans are able to access insurance if the rolls at the state level are not increased, as the justices apparently have just ruled. Juan Williams with me now, Fox News political analyst. Juan, your reaction?
Well, I think it's a big day for the Obama administration, Bill. I don't think there's any way to get around it. This is a tipping point in terms of public perception of the law. For so long, we have heard the critics loud and clear in terms of the excesses of the law and the potential for damaging relationships between patient and doctor. But now we see that the court has affirmed that it is constitutional as a tax. I think you're going to see people now become accustomed to the idea and focus more on the benefits that attach to the Affordable Health Care Act, including closing the donut hole and protection for young people under 26, allowing them to stay on their parents' insurance. I could go on. But all of those consumer-friendly features, I think now are going to come into sharper focus as people become accustomed to the idea that this is the law as affirmed by the Supreme Court. So to get to Karl Rove's point, it is vindication for the president as his signature legislative victory during his first term. And I think it puts Mitt Romney and the Republicans on the defensive to say, not just would we repeal it, but why do we think that we can do a better job in what has been a historic struggle to try to provide health care across the country
and
for
as you
everyone.
know, over the past few months, there has been common ground spoken publicly on behalf of Republicans and Democrats that some of those provisions are good things. And also the insurance companies, too, have voiced yet again their favor for them. The judge is back with me now. Specific question on how you fund or find insurance for more people at the state level if the Medicaid provision is declared unconstitutional.
Well,
how do you do that in the state
I
capital?
don't know how you do it, and candidly, Bill, we have not yet seen that part of the opinion.
They haven't held it unconstitutional.
It appears that what they've held unconstitutional are the punitive aspects of it. The federal government withholding other money that it owes to the states on other issues if the states don't comply with its command.
Here's exactly what the court wrote. This is from Chief Justice Roberts. Just so our viewers know, there was one provision of this law that required a huge Medicaid expansion in all 50 states and said to the states, if you don't do it, if you don't put all these poor, lower income folks on your Medicaid rolls, you're going to lose your existing Medicaid. So it was a big stick over the states. This is what the Chief Justice has written. Quote, nothing in our opinion precludes Congress from offering funds under the Health Care Act to expand the availability of health care and requiring that states accepting such funds comply with the conditions on their use. What Congress is not free to do is to penalize the states that choose not to participate in the new program by taking away their existing Medicaid funding. So they can't use that stick on the states of saying, if you don't do what we want you to do, expand these rolls, you're going to lose your existing Medicaid
what you're
funding.
saying
that is
then,
a victory for the 26 states.
and what you both are arguing here is that is what is being printed on this blog. The Constitution requires the states have a choice.
Yes.
They have a choice about whether to participate in the expansion of eligibility. If they decide not to, reading here, they can continue to receive funds for the rest of the
Can we
program.
get back to Chief Justice Roberts because he's summarized what he's written in 3 lines. The Affordable Health Care Act is constitutional in part and unconstitutional in part. The individual mandate cannot be upheld as an exercise of Congress's power under the Commerce Clause. That clause authorizes Congress to regulate interstate commerce, not to order individuals to engage in it. In this case, however, it is reasonable to construe what Congress has done as increasing taxes on those who have a certain amount of income. Stated differently, Congress's ability to regulate human behavior is limited, but Congress's ability to tax and spend is unlimited.
A couple of important points here. The court's decision to rule as they did on Medicaid is going to be a big deal. This act covered the very poor and sort of the next level up, middle class to lower middle class. Those were the ones who were covered by the expansion of Medicaid and then these exchanges that have been set up by the states. If the states have the ability to keep their existing Medicaid programs and not expand them, and we're still figuring it out, but if that's what this meaning is of this ruling, that they don't have to expand their Medicaid rules as Congress told them to do, then where are the very poor going to get the health care that the Congress put in place for them? That, as I'm reading it, may be in jeopardy now. I want to make one other point. The taxing power. President Obama on ABC News, September 20th, 2009. George Stephanopoulos. This is a tax increase about this law. President Obama, no, that's not true, George. For us to say that you've got to take responsibility to get health insurance is absolutely not a tax increase. Nobody considers this a tax increase. And on he went and repeatedly said this is not a tax increase. When they went into court, they said something very different, and the Supreme Court accepted that legal argument.
And the way this tax is expected to be implemented, I think it's fair to call it a tax now, regardless of what the debate was 3 months ago.
It's being taken out of your tax refund.
Correct. And that is how the government will collected.
It's the most bizarre tax in the history of the country because it's not related to your income, it's related to your behavior, and it does not fall on everyone equally. It only falls upon you if you refuse to comply with what the government has commanded you to do, and that command it doesn't have the power to articulate under the Commerce Clause. Look, we have to read this. We have to study it. As Megan points out, there may be parts of it that are inconsistent with other parts. We won't know until we see how this plays out.
In general terms, Medicare covers all Americans. Medicaid covers the poor. And that's the program that we just discussed here on item number 4 for expansion. Now, back to Shannon Bream in a moment, but first Brett Baer. And I think, Brett, what we need to discuss this, and you just touched on it moments ago, is the historical perspective of this court when Chief Roberts sides with the left-leaning members, the left-leaning justices on the court.
Yeah,
28 minutes into this decision, or give or take a few. How can we analyze that now?
Well, one thing is clear. Presidents do not know what they're going to get when they nominate someone to the Supreme Court definitively down the road when they're nominated. Justice Roberts was nominated by President George W. Bush. He has now twice, in 2 big cases, none bigger than this one we've just heard, sided with the left of the court, the liberal bloc. This is reminiscent of President Bush's father, President H.W. Bush, who appointed Justice Souter and often sided with the left side of the court. President Eisenhower appointed Earl Warren. President Nixon appointed Justice Blackmun. And many of those justices sided with the left side of the court. It was not predictable. This is a major, in historical perspective, for the Chief Justice in this big of a case to side as he did today is a major, major moment for this court and in perspective of President Bush's nomination.
You're right about that, and you make a good point. Justice Kennedy now reading a dissent. We're told he started with the following phrase inside court, quote, "The act is invalid in its entirety." That from Justice Kennedy, who arguably had the most pointed questions for the government lawyers 3 months ago. Greta Van Susteren on the steps now of the U.S. Supreme Court. Your reaction and what's going on around you, Greta?
Well, my reaction to what's going on around me is quite pandemonium, a lot of protesters. But behind me, what happened just inside the Supreme Court is rather significant. It's a huge win for the Obama administration. But what's so fascinating, I know we've been talking about it on our air, is that when this statute was passed, nobody wanted to go near the word tax with a 10-foot pole. That's a poison word as a politician. So Democrats are very specific. This is not a tax. However, when they got down to Florida for the first challenge, and I was in the courtroom, that's when the Department of Justice, the lawyers, not the politicians, got into it. And the lawyers got into it and say, whoa, this is a tax, which is very different because that is more expansive power on the part of Congress compared to the Commerce Clause. So that's when we first heard tax. And of course, here what the Supreme Court is saying is what the Chief Justice says is just because they called it something else, the politicians didn't call it a tax, that's like forbidden. Just because they called it something else doesn't mean that it isn't a tax. And the Supreme Court, at least as far as I can conclude reading, this is a very voluminous decision. This is a tax, and Congress can tax. So huge win for the Obama administration. Bigger win for the lawyers because the lawyers were smart. They sat back while the politician says this isn't a tax. It was the lawyers who finally went and said this is a tax, thereby enabling the court here to agree with them and say it's a tax and give them power.
We went through 4 questions posed to the court 1 hour ago. And one of them on severability, Greta, apparently was never even addressed and did not have to be addressed because the mandate was upheld. Number 3, the item of severability is, can the law stand if the mandate is taken out? I don't believe that was even addressed by the justices because item number 2 was upheld. Is that accurate?
Well, that's irrelevant. I mean, the whole question of severability was only relevant if some part of if the mandate was tossed out.
Correct.
Now, what I haven't gotten to exactly is this whole Medicaid expansion issue. I don't think that was declared unconstitutional. I have to read through this. There are some sort of limitations on it, but the severability clause only came into effect, at least as I understand it, is if the individual mandate clause were declared unconstitutional. Then the question the court would have had to consider is, do we toss the whole statute out?
Understood.
Obviously, that did not happen.
Greta, what is your view 25 minutes into this on the point that Brett was making a moment ago about Chief Justice John Roberts?
Well, I guess that, I mean, I could say rather flip, he's made up for making that mistake at the swearing in.